Hello, hello, hello. This is Attorney Mike Grevin coming to you from Chicago. As usual, we got all sorts of stuff. I got a lot of people to thank. The Discord. Who else? Some of this is Natalie's fault, as usual. Rhonda Sue in Kansas. Kristen in Traverse City. And there may be more I forgot. I can't remember what's in here. There's so much goodness. But I had a late edition that is entirely Natalie D's fault. Let's start with that, shall we?
So, this is all an act for me, for him, because I did not want to be his lesbian lover when he transitioned to be a man.
Okay.
I really don't care what he does.
Okay. Hearing that song in my head, another one bites the dust. We keep getting emails about people leaving.
Reasonable time.
Oh, it is true. It's like almost every week we get at least one or two that are, we're out of here. All right.
Your Honor, may I ask whether it's not a stenographer here in the courtroom today?
All right. Somebody put this in the Discord. Thank you very much. This knucklehead Yon is being a knucklehead in court. Let's watch.
Stenographer is appearing by Zoom and is taking the recording down as authorized by Illinois Supreme Court rule.
Is there a reason for that?
It's just the way it's happening
It's
today.
natural that the stenographer is usually in the courtroom, right?
Mr. Yon, I've answered your question. There is a stenographer taking the proceedings down via Zoom.
I also would like to object to the media being in the courtroom while I've not been given notice of that 14 days prior, and I've not been given notice today. So I'd like to object to that, and this being filed under coverage on the news this afternoon, as it always is. Also, Your Honor,
Hold on, your objection's noted for the record and overruled. I have nothing else to take up in your cases today, Mr. Yon, so I'm going to remand you to the custody sheriff.
Your Honor, I am my own attorney. I have some issues to take up with the
If you
court.
file a written motion, notify the state of those issues, and then we can schedule those for a hearing.
It seems like things don't get filed, Your Honor. The clerk just did not file them. That's one of my reasons. Things often do.
Mr. Yon, you're remanded to the custody of the sheriff.
The clerk will start filing my stuff. The clerk will never file my stuff. That's why I'm sitting here trying to argue. Piece of shit.
Let's go.
He's done. I'm tired of this shit. Y'all just railroad the shit out of me here. Fucking ain't even no stenographer here. Tired of this stupid ass shit.
Bye-bye.
Thank you.
Court calls the case, People versus Kyrie Morgan.
Alex Chabalowski for the people.
I added the silent goat for all the complainers about the goat screaming.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Morgan, who I did see earlier, Judge.
Now are you just going to object to cute goats? That's what I want to know. Are you just going to object to cute goats?
Hey, how you doing today, Jan?
Good. State your name.
Kyrie Morgan.
Okay, what are we doing?
Your Honor, it's my understanding Mr. Morgan wishes to request new counsel on this matter.
Okay, what's the problem?
After the last time I seen you at court, you told me to call the courthouse. I called the courthouse, got a contact. They told me they're in rotation with public defenders. Then
This guy looks familiar. Have I done a video on him before?
they sent me the letter when I go to court. Then I never hear from my attorney. Then every time the day before court, they call see if I come into court. Like yesterday, they called me, said they got an offer for something that I didn't understand. So basically, either waive my prelim or take a plea, and I didn't understand. And then he's just real disrespectful, and I just
Mr.
feel like
Morgan, I'd ask you not to discuss you discuss what you want, but anything you say can be used against you, but go ahead.
I mean, he asked me what happened. I'm telling him what happened. We was on the phone. You said something about the offer. I didn't understand it. You was disrespectful, and I just feel like you not trying to.
Maybe you weren't listening. Mr. Gaddy's not disrespectful. If you ask him to explain it to you. I've never known any client of his to come before this court and say he was disrespectful or wouldn't explain it. Maybe you ought to take the time to do that. That's not a basis to try to discharge your counsel. So that to the extent that is a motion, it is denied. What do we want to do with this case?
I just like Judge Simpson's. Maybe, just maybe, this is a you problem.
Your Honor, I have had someone send an encrypted police report to Mr. Morgan. I believe that Mr. Chablowski is also trying to get us some video on this. I'd ask the court to adjourn it so that we can go over the offer some more if Mr. Morgan wishes to, and he can review the police report on his own.
August 3rd, 2023, 9 a.m. Bond continued.
Okay, that being no. The court will call State of Kansas versus David Austin, case number.
Oh, here we are. Here we are. The famous Peckerwood clip. I got it's out of Kansas. It's fantastic. All you have to remember is do not call him Peckerwood. That's all I'm saying. He doesn't like it.
23 CR 179. Announce appearances.
May it please the court, the state appears by Aaron J. Cunningham, Assistant Ellis County Attorney via Zoom.
Your Honor, Mr. Austin appears with Richard Beckman by Zoom.
All right. This before the court on a status hearing, and also because the defendant filed a pro se motion for ineffective assistance of counsel. The court's reviewed the file and notes that Mr. Beckman was appointed counsel for Mr. Austin on June 9th by Judge Flax, and that Mr. Austin, 12 days later, on June 21st, filed a motion for ineffective assistance, claiming that Mr. Beckman didn't have his best wishes in mind. He was
another genius who knows more than his attorney. Here we go.
Inexperienced in cases such as this and isn't fighting for me. First of all, the court will make a finding that Mr. Beckman has extensive experience in cases such as these. So that isn't a sufficient basis. I don't know about best wishes or fighting. I don't know how much you can do in 12 days after an appointment, but Mr. Beckman.
I'd be happy to tell you if you'd like to know, Your Honor.
Yes, I was going to call on you at this point.
I was appointed, I looked at my billing sheets. I was appointed on June 9th. On June 11th, I filed the motion for discovery. I sent an analysis letter to Mr. Austin. He'd already called me 2 or 3 times by that time. By my count, I've talked to him at least 12 times since I was appointed. I sent him 2 letters. I had a jail visit on June 14th. I've emailed Mr. Cunningham twice on June 14th and June 19th about pleas. So I think I have worked very hard on this case. If a client doesn't want an attorney, it's always troublesome.
I did not know that.
Yeah, Mr. Austin did call me, I think, after he filed the motion. That was filed on the 21st. He called me at some point after that, and I told him till this was resolved, I wasn't going to visit. He'd asked about the last offer that I'd made to Mr. Cunningham. So I emailed Mr. Cunningham on June 19th. Aaron and Mr. Cunningham emailed me we had discussed on June 14th. On June 19th, I sent Mr. Cunningham another email, and I think that Mr. Austin was asking about the results of that. So that's where I'm at. I think I've done a lot of work in a short time in this case. But, if he wants another attorney, that's fine with me, Your Honor, for whatever that's worth.
Well, Mr. Austin, did you hear what Mr. Beckman just recited for the record?
Yes, I do.
I'm asking you, is just this. He's given a variety of dates concerning conferences, emails, telephone. Is that accurate?
Well, somewhat. The reason why I say what I do is because I asked him he had sent me a copy of the emails that him and Mr. Cunningham had replied to. Okay. I feel that, I'll just go ahead and read it to you. Okay. It says,
please do.
On Sunday, June 18th, 2023 at 2:50 p.m., Mr. Cunningham wrote, Peckerwood, your client's better known alias in the drug world, is not getting a plea that does not involve DOC. KDO
I love this. As a former prosecutor, this is the way it goes down. The prosecutor is loving it. He's bottom left. He is absolutely enjoying the hell out of this. He's living rent free in this guy's head. He knows it. There's no remorse, nor should there be. It's funny.
You'll see, he's an e-history because he's been dealing forever. Okay. The only reason why the lucky duck doesn't have a special sentencing rules because in their infinite wisdom, the Kansas Sentencing Commission determined that in order for a special rule number 26 to apply, they have to be convicted of a simple possession, not possession with the intent to distribute or distribution. So you can possess it with the intent to distribute or distribution, but it's not a prior possession for the special sentencing rule. Completely asinine. Okay, I would expect nothing less. He's a drug dealer who needs to go to prison. He knows the routine. He needs to take his lumps and go. That's very unprofessional. Very unprofessional. He's calling me out of my name. Okay. And Mr. Beckman wouldn't do nothing about it. I mean,
he is holding back a smile so hard right now.
I'm a civil.
Well, Mr. Austin, let me ask you something. You've got some. I've had you in court before. I recognize you, and
yes,
I know your nickname. And it seems your complaint is about Mr. Cunningham's conversation.
Well, I had asked Mr. Beckman to file a motion for what do you call it, a change of venue, and he said he couldn't do that. He said it wouldn't work because I ain't gonna get no type of fair trial in front of Mr. Cunningham. I ain't gonna get nothing. You know, I'm an addict. I'm not a drug dealer. I would like to get a treatment. Get an evaluation.
Mr. Austin, that's not really relevant for today. I mean, that may be a discussion we have at a later date, but not today. Okay. Today, I'm going to tell you right now, Mr. Austin, you said basically what Mr. Beckman has relayed to the court that he has done in this case is accurate. Mr. Austin, that is more than any other lawyer I know of. And I can assure you more than any other attorney I would appoint. I am absolutely shocked he has done that much already. Now, you may not like the tone Mr. Cunningham is using in response, but what would you expect Mr. Beckman to do?
How can Mr. Cunningham get away with calling me out of my name? Shouldn't it be Mr. Austin, said Peckerwood, better known as known alias in the drug world? That's very unprofessional.
Well, except that, Mr. Austin, you've conveyed that is your nickname. I remember in court you told me that was your nickname.
Yeah, but does that give any people like him, I mean, the right to call me out of my name? I mean, anybody else could. Okay,
well, Mr. Austin, you used that name. You told me that in court that was your nickname. Did you not?
Okay.
I mean, yes or no?
Okay.
I've been called PW. I don't go by that. That's what people call me.
Okay. And so people call you that, you recognize that, and Mr. Cunningham, whether he should have used it or not, I'm not here to weigh in on, but he knows that from court that you have used that name or been referred to by that name.
Right. But he's not the only one.
I think you even have it tattooed, do you not?
Well, yeah, I do. Yeah.
I mean, nobody. Well, no, it's not irrelevant. You're complaining that he used a nickname that you have tattooed on your body and that you recognize as a name used in the community.
I know, but he's not.
Thank you, Judge, for saying what we're all thinking.
The only one that does it. Detective Hancock does it.
Sure.
Green does it.
Well, in your honor, I might say, I did tell him that there is no basis for change of venue. And I think that's what he might be complaining about. There is no basis for a change of venue.
Mr. Austin.
Yeah. I'm listening.
You're listening. Good.
Mm-hmm.
I'm going to ask you this. If you want another lawyer, I will appoint who's ever next on the appointment list. It's not who you get to pick. And it's going to be the last lawyer I appoint. So, and I'm going to tell you that my expectation is the next lawyer will not even they'll be very competent, but what Mr. Beckman did, frankly, at this early in the case is above and beyond what I would have expected. and is more than a demonstration of being competent counsel. But here's the deal. You don't get to keep doing this. You may be getting advice up in the jail, and I can assure you that I look at each case on its own basis. And generally, I warn defendants that I'll make one change, but you don't get a next one unless something dramatic occurs in that representation. So be careful what you ask for, because if it's granted, you may not like the result, but it's up to you. So I'm going to ask you again.
I'll just keep this. I'll keep it.
Well, I think that's a very wise choice. Now, my question is whether Mr. Beckman wants to remain your lawyer after what you've done in filing this motion. Mr. Beckman?
Your Honor, you know, he didn't call me names. I do believe I have every client's best interest at heart. The problem with these cases, as the court well knows, the plea that Mr. Austin wants is dependent on the state as well as Mr. Austin. And the problem he's got a registration charge that I've tried to explain to him makes negotiating very difficult. So I guess with that background, if he wants to keep me, I'll stay in. But I don't think I can get him the plea that he wants. And if that's frustrating to him, maybe he should get another attorney that maybe another attorney can. I just don't think I can do it. And so anyway, I guess that's where I'm at. I'll stay, Your Honor, if that's what the court wants, and if Mr. Austin wants that, based on what I just said.
Mr. Austin?
I will say, there ain't no sense in changing it. Just start the process over. Could get worse.
Good, but you have to understand that Mr. Beckman has indicated that he does not believe he can achieve the result you want. And you have to understand that's not his decision. That's a decision in the prosecutor's hands.
Yeah, I understand.
Okay. So you want to stay with Mr. Beckman?
Yeah, I'll stay with him.
Okay. Well, Mr. Beckman, I know that this will be a challenge. This is not a good way to start your representation of a client, but based on what you've done, the court makes a finding that you have been more than effective. Court already knows you are experienced, and the defendant's pro se motion is overruled. Do we need to cover anything else today?
Not from the state's perspective, Your Honor.
No, I think we have a status conference. I had dental work this morning done, so I'm having trouble. I'm still numb a little bit. I think we have a status conference Tuesday. And I guess, Aaron, while we're talking, I had sent you an email on June 19th about where we were at. So maybe you could reply to that sometime before Tuesday.
Yeah, I see that, and I think you even followed up on June 22nd, so I'll get back to you.
Okay, thank you.
That must be a status in front of one of the magistrates regarding scheduling the preliminary hearing.
It is, Your Honor.
Very good. Okay. All right. So you've got a status hearing in front of the magistrate judge, Mr. Austin, next week, Tuesday. That would be on the 18th, and that'll be about discussing scheduling a preliminary hearing. I won't be the judge. It'll be one of the magistrates. You understand?
Okay. Yeah, I understand.
All right. Very good. Okay. Anything further then for this morning?
Not from the state.
No, Your Honor.
All right.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Suppose.
This is case number 21-170-663.
This is
Louis
Matt, I warn
Bartholomew
you.
versus MJ Realty Service, PLC. Could I have your appearances, please?
Miroslav P. Volchko appearing on behalf of plaintiff Louis Bartholomew, P21851.
Mr. Donald?
Good morning, Your Honor. Robert Donald, P4886 on behalf of the defendant.
The record should reflect that present but muted is plaintiff Mr. Bartholomew. We are here today on defendant's motion for reconsideration of my denying the motion to set aside default judgment.
May I, Your Honor?
Oh, please.
So, Your Honor, this matter was well, when we were last here, plaintiff was not here, so the court set
Plaintiff's lawyer was not here.
I'm sorry, Your Honor. Plaintiff's lawyer was not here, so this matter was set over for today. And prior to our last hearing, Your Honor, defendant was not before the court because plaintiff had told the court and defendant that he was unavailable on the date that the court held the hearing, which I have included with my motion and the email where plaintiff indicated he was not available on that day and indicated to the court that he would be available sometime after May 11th and that the parties would consult and indicate to the court when that would happen. Everything after never happened. So the court held the April date where plaintiff indicated that they were not available. Defendant failed to show up and plaintiff obtained a order and obtained an order. We're asking that the court reconsider that order as pursuant to what plaintiff indicated they were unable to attend that day, and then in turn did attend that day without informing defendant, and then went on to obtain the order. When defendant reasonably, I'm sorry, Your Honor.
Donald, what is the palpable error by which the court was misled? That's what's required for reconsideration. Demonstrates
again, Your Honor,
palpable error which must result in reversal of decision.
The palpable error, Your Honor, is that plaintiff indicated to the court and to defendant that they were unavailable and misled the court and defendant, and defendant reasonably relied on the fact that, I'm sorry, Your Honor.
I'm a little concerned here. Maybe I'm confused, but my understanding of the way the case has been proceeding, indeed, my understanding of the way I run my docket is that I decide if there are adjournments or rescheduled. Did I enter an order saying that the April date would not proceed?
If you look at your, I'm sorry, Your Honor, if you look at the email, didn't order.
Is that email from the court?
No, Your Honor, not an email from an order.
And the court speaks to its written orders, right?
This court speaks to its written orders, absolutely, Your Honor.
So what I had before the court was a request, not an order, a request to reschedule. The court determined not to reschedule. So how could you, in the absence of an order from the court, decide that I'm going to have my schedule dictated by counsel for the plaintiff?
And Your Honor, again, if you read the email, the email of whom? I'm sorry, Your Honor.
The email of whom?
The email of the court to Mr. Vico, the plaintiff.
What does it say?
The email reflected that the court would accept what the parties were going to schedule after the 11th. And I've included that email with the with my pleading, Your Honor.
Let me hear from Mr. Vico.
Yes, Your Honor. Thank you. Let me go back a little bit and correct the record from the prior statements. Both plaintiff and plaintiff's counsel appeared at the hearing on the 27th.
Yeah.
I believe earlier there was a comment that plaintiff did not appear.
No, that was not my comments, brother counsel. But please go ahead.
Well, if it's correct on the record, that's my only point. In addition, Your Honor, the court's statements are well placed. There was no adjournment made by the court that we're aware of. nor was there any court order entered to that effect. And that's why we exercised our due diligence and checked the court website, and that's why we appeared at the hearing. And it seems to me that counsel and both counsel for defendant and defendant could have done the same due diligence, which they apparently didn't do. That's our position, Your Honor.
My problem here, Mr. Donald.
I really like brother counsel. I thought that was actually kind of sweet.
Is that when and let's go back to the setting of the April date.
Yes, sir.
How did that happen? It happens the way all of my pretrials are set. I say I want to do this on such and such a date. Is that date okay with each party? And everybody says yes. So this was not a date which was set without agreement of the parties. This date being set with the agreement of the parties, the court issued an order for that date.
Again, if I may, Your Honor, if that is not how that transpired, that date of April. So if you again read the email that the court sent on Tuesday, March 28th at 11:02 a.m., it says, I spoke with Judge Robinson. Please provide at least 2 dates next month for the appointment for your adjournment that is convenient for both counsel. Once I receive those dates, no need to appear to tomorrow's Zoom hearing.
And were those dates provided?
No, Your Honor, because again,
I'm sorry?
No, Your Honor.
Okay, so let me make sure I understand this. The court.
This is what's kind of fun. It's the slow burn. It goes on forever, but he just gets slowly crankier and crankier, and for good reason.
Provided, or should I say, my court clerk said, give me 2 dates next month that are convenient with both parties, and if you do that, there will not be necessary to appear. And it is uncontroverted that the 2 dates were not provided. Have I missed something?
No, Your Honor, you are not.
So then, again, as usual, I'm confused. An order setting a date.
Translation, I'm confused means you're in trouble.
Agreed to by the parties. Something comes up. An email is sent, a request is made to adjourn that date, and the court's response is, give me 2 dates next month that are convenient with both parties. If that is done, it won't be necessary for the appear for the scheduled hearing.
All right.
2 dates never provided. 2 dates
so
not
then, Your
provided,
Honor,
all uncontroverted. So how do we get to a point where there's palpable error when the order had been entered with the date agreed to by all of the parties? A conditional, if you do this, you can get a new date, had been granted, and the if you do this was not done. How do we get to palpable error?
So again, Your Honor, going back to the email, so then according the plaintiff, not plaintiff's counsel, then responds and says Wednesday, April 26th and Thursday, April 27th are good dates. And then plaintiff's counsel responds and says that those are not good dates, Your Honor.
So then help me out. And once again, I'm still confused. You were made privy to communications between plaintiff and his lawyer.
I'm sorry, Your Honor?
But you were made privy to communication between plaintiff and plaintiff's lawyer. I'm still missing. The court being provided with 2 dates that were agreed to by the lawyers. I'm still missing that. I didn't see that.
Okay. And again, Your Honor, so that was not a communication between plaintiff and plaintiff's counsel. That was a communication between plaintiff and the court.
Okay.
And then once that communication,
And then what were the dates that were provided to the court? I got it on one side.
all right, so the dates that plaintiff provided to the court was April 26th and April 27th.
And in the way we operate our litigation, who speaks for a represented plaintiff?
The lawyer.
Lawyer.
Exactly, Your Honor. So then,
again, I'm back to my same problem that the lawyers had been told, if you want a new date, a date different than the dates you had already agreed upon, then you got to provide 2 dates next month that are agreeable to both of y'all.
okay.
Not done. That's uncontroversial.
All right, I think I'm understanding the disconnect, Your Honor. So, Your Honor, on March 28th, when the hearing was the next day, the March 29th date is when the hearing was going to happen. The court never got from the 2 parties a date that was acceptable pursuant to what the court says, where the 2 parties say this is acceptable.
And wasn't that the condition?
There was never,
of adjournment?
I'm sorry, Your Honor.
Wasn't getting those 2 dates from the parties for alternate dates, wasn't that the condition of the adjournment of the scheduled hearing? That's the point I'm trying to make here. I'm having trouble with your argument, sir.
Provide. All right. I'm sorry. I can read you your I can read the court's email to us again, Your Honor. And it doesn't seem as if that is a condition of, it says, I spoke to Judge Robinson. Please provide at least 2 dates next month for your adjournment that is convenient for both counsels. It doesn't seem from the plain reading of, I'm sorry, Your Honor.
Continue to read the email, sir.
Once I receive those dates, no need to appear to tomorrow's Zoom hearing,
Once
which was
I
the 29th.
received those dates,
I'm sorry,
it
Your
is uncontroverted. The court did not receive those 2 dates, sir.
So that means that, and I agree. It is uncontroverted.
Then
so
nothing
then
changed.
So then, I'm sorry, Your Honor.
Then nothing changed. You already had a scheduled date. A problem arose and the court said, give me 2 dates next month that are convenient for both counsel. And if you do that, there won't be a need to appear for the hearing.
On the 29th.
Everybody agrees the 2 dates were never provided.
So
why then do you believe, in the absence of an order from the court, that the scheduled hearing was not to proceed?
The scheduled hearing was for March 29th, Your Honor. So I agree that if the 2 dates were not provided, the date that on the 28th, because the condition was not met, that 2 dates were not provided, the hearing on the 29th should have taken place. But it did not take place. Neither party appeared, Your Honor. So we are in absolute agreement on that.
Okay, so both sides agree that you disobeyed the court's order. Continue. And again, I'm still looking for my palpable error by which the court was misled. I don't understand how, in the face of a written order, failure to appear is a palpable error.
Well, again, Your Honor, so again, using the reasoning that the court has laid out for us, the hearing on the 29th should have happened because the condition preceding did not happen.
Okay.
Further, the court then sets another date pursuant to a plaintiff's email, not what the court has indicated in its email.
Okay.
And the defendant reasonably relying on what the plaintiff, not plaintiffs, or I should say plaintiff's counsel, not plaintiff, saying that I can't make it on this day. Then if you read some more, Your Honor, up further.
Did you get an order from the court for the date when you didn't appear?
Did I get an order on the
court scheduling that date?
I did not get an order from the court to appear on the 28th, Your Honor. No, I did not. And again, that is the crux of the matter.
Oh, it gets
now,
worse.
I did get an order not dismissing, but from plaintiff indicating that you had dismissed the matter and assessed costs. And I got that from plaintiff. Then I filed our motion to reconsider, which at the time when we were here last, apparently the court did not have, because then the court indicated that they didn't have an order to be reconsidered. So then the court indicated that it would draft an order, and I could then ask for that reconsideration at this date today. The palpable error, Your Honor, is plaintiff misleading the court and misleading defendant's counsel as to could they appear that date, then appearing on that date after saying they could not appear on that date. They misled the court and plaintiff's counsel, which, Your Honor, again, using the court's justifiable rationale, the date on the 29th absolutely should have happened because no dates were given. The two dates were not given on the 28th.
Mr. Brico.
Yes, sir. Yes, Your Honor. Are you asking me to reply to that?
I'm asking if there's anything else you want to tell me.
Obviously, with the court's position, and again, no order was ever entered by the court adjourning. I think we're talking about the hearing on April 27th, aren't we, Your Honor?
That's my understanding.
That's mine also. Other counsel keeps referring to a hearing on March 29th.
Yeah, I'm
not sure what that has to do with anything.
Yeah, I'm having trouble with that.
Yeah, I'm glad you are, because I am too, Your Honor. In addition, it was clear that there was a hearing scheduled on the 27th of April, which hearing was held by the court pursuant to its original order. No order was ever given by the court to adjourn that date. And again, exercising our due diligence, Your Honor, and we weren't the moving party. It was certainly incumbent on moving party to perform due diligence and look at the court's docket online, which is what we did, to make sure that the hearing was being held or whether it was adjourned. And again, we saw no order adjourning it. So that's why we performed the due diligence, because without an order, in our opinion, that hearing date stood as ordered by the court.
That's my understanding of how things work.
If I may just briefly, Your Honor.
Yes, sir.
The order issue, and I understand that while my motion is in regards to the hearing in April, the order for the hearing on the March 29th was the order that I am now saying we should have appeared on the 29th. And plaintiff's motion to adjourn that hearing on the 29th because he was unavailable is where we're at. Because on the 28th, before that order that ordered us before you on the 29th, plaintiff asked for another date. Plaintiff asked for another date. Plaintiff then failed to do what the court ordered them to do, which was to give the court 2 new dates to get another date. So then the March 29th should have happened, Your Honor, because plaintiff did not do as ordered and got another date anyway.
All right.
May I have a final reply to what defendant's counsel is referring to as an order is not an order. It was an email. And the condition, as this court has pointed out repeatedly, the condition of the email was never met. Consequently, the April 27th date stood as originally scheduled. This is all pretty straightforward, Your Honor.
Yeah, the problem that we have here is that we have your client stepping out of his lane. This whole confusion is because your client improperly communicated with the court. That's not his business. He has a lawyer. That's the lawyer's job. And that's the whole problem, crux of this whole thing. And although I think it is quite clear that it was incredibly sloppy practice on the part of Mr. Donald to fail to appear for a scheduled hearing for which there was a written order in the absence.
Who's up for an incredibly sloppy practice Law Talk with Mike shirt?
Of an order altering that. The fact remains that the predicate setup for this screw up was your client's doing something he ought not to have done. If your client wants to communicate with the court, then go to law school, get admitted to the bar. This is not the Gong Show. So what I'm going to do is as follows. I am going to reluctantly, because I do not like rewarding sloppy practice, Mr. Donald.
I understand, Your Honor.
Motion for reconsideration.
He's cool.
I am going to set the matter for a pretrial August the 7th at 11 o'clock. Does that date and time work for everybody?
Give me one second, Your Honor. Let me check my calendar.
We all hit the gong in our head at some point.
You said August the 2nd?
7th. August 7th, excuse me.
Sorry. Thank you, Your Honor. Thanks for the correction. That date is fine with me. What time, Your Honor?
11 o'clock, like today.
Okay.
Mr. Donald?
That date is fine with me, Your Honor.
All right. Well,
and
I'm sorry. Go ahead. What you want to say?
I was just going to say, just so that I'm clear, Your Honor. So the pretrial will that date, the August 7th date, will that be to argue our motions to some, because both parties had submitted a motion for summary disposition? So I just want to be clear what the pretrial date is, Your Honor. That's all.
The pretrial is to just get this file back on track.
Okay.
Because
that's fine,
we have a situation where, if you recall, the court had already entered a default judgment in this matter.
That is correct, Your Honor.
And when I look at the file, it looks like the last time I looked at the motion, at the default judgment, there was the motion. I didn't see motions for summary disposition. What I saw was a motion to set aside the default. What I saw was a request for a debtor's examination. Not the same thing as motion for summary disposition. And what I saw when I reviewed the register of action is the court denying on April 27th the motion to set aside the default judgment, saying that there was to be a 7-day order submitted. Then we had the supposed subpoena that was issued for May 25th for the debtor's examination. Then the motion for reconsideration was filed. Then we finally find ourselves here. So the posture, as I understand the case, is that the case is in a situation where the only thing matter to be heard is not a motion for summary disposition. It is a motion to set aside the default judgment. And I'm not understanding where this summary disposition comes from.
That's fine, Your Honor. I will address the default at our next hearing.
So this is a situation. I'm going to grant your motion to reconsider my decision not to set.
Oh, good Lord. I didn't even catch it the first time. So there was a default judgment entered. You can't, and he's talking about all this other stuff. You can't do anything until you vacate the default. There's currently a judgment. It can be vacated, but that's the only way forward. Otherwise, you have a judgment. That's it. That's how this works.
Set aside the default judgment. I will hear argument on that August 7th date to yea or nay set aside the default judgment. If there are any further communications with the court, they will be from the lawyers only. Do we have anything else we need to resolve today, gentlemen?
Yes, one last, Your Honor. We've been, as you know, there's been a judgment entered in this case by the court, and we've been trying to schedule a creditor's exam resulting from that judgment. Can we address that issue, Your Honor?
Well, let us assume for...
Oh, sweet Jesus. This is dumb, too. He's saying, I want to get it back on track and address whether or not we're going to, the motion to set aside again. Clear that hurdle before we get into the post-judgment proceedings. I'm sorry, I'm nerding out here, but both of you, forget all your other motions. That's the only thing on that's before the court at the moment because it's dispositive of everything else.
Purposes of our discussion, that I decide not to set aside the default judgment in August. What will you have to do? Schedule a creditor's exam.
Correct, Your Honor.
Different by waiting until that time. And again, we have this failure to communicate because we have unauthorized contact with the court by your client. So what?
Okay, so now I wasn't paying that close attention the first time I went through this. So now he hammers this guy's client because his attorney just went too far. It's subtle, but that's what's going to happen here.
What we're going to do is Mr. Donald is going to submit an order that is going to grant the motion for reconsideration. And in that order, he is going to schedule for August 7th at 11 o'clock the defendant's motion to set aside the default judgment. If either of you wish to file any supplemental pleadings on the subject of setting aside the default judgment, the court will be willing to do so. It appears to me, looking at my order dated June 6th, that I had intended to set aside that judgment, but I looked like I wrote the wrong word. It looked like I wrote deny when I wrote, I should have written granted. Why would I assess attorney fees if I decided not to set aside the default judgment? But that'll be heard and decided August the 7th at 11 o'clock. The lesson, Mr. Bartholomew, you want to communicate, that's why you have a lawyer. The lesson, Mr. Donald, is that the court speaks by its written orders. The lesson, counsel, both of you, is that if you have a condition preceding to getting relief from the court and that condition preceding is not met, then the court's original order stands. Is there anything else, gentlemen?
Your Honor, I apologize. I didn't have a piece of paper to write some notes here. Would the court mind repeating its conclusion here?
The order is as follows.
Get a pen, dude.
The motion for reconsideration is granted. On August 7th at 11 o'clock, the court will hear
by in the background
the motion to set aside the default judgment.
Thank you.
If either of you wish to supplement your existing pleadings on that question, setting aside the default judgment, you may do so.
And you also said the defendant is to submit a proposed order.
No, the plaintiff, who is the moving party, is submitting the order.
I'm sorry, Your Honor. The defendant is the moving party.
The defendant is still submitting the order.
I'm sorry, Your Honor.
Defendant is submitting the order.
That's what I thought. That's what I said.
Granting the motion for reconsideration.
And setting the hearing.
Calendaring the hearing, August 7th, 2023 at 11 o'clock on the motion to set aside the default judgment. That's what any party who wishes to supplement the pleadings previously filed on the motion to set aside default judgment may do so.
Just finishing my notes, Your Honor. Thank you for your indulgence.
Don't thank me, the taxpayers, buy my time. Is there anything else, gentlemen?
Your Honor, if I may, I just wanted to take this time to apologize to the court. I misunderstood because at the time Mr. Velko was in the hospital, I wasn't sure whether he would be able to communicate with the court. I realize now that I should have reached out to Mr. Donald, who would have been able to communicate with the court. So I just wanted to apologize for that misunderstanding. It won't happen again.
Stay in your lane, Mr. Bartholomew.
Your Honor, to expand a little bit on Mr. Bartholomew's comment, both my wife and I did have a serious case of COVID, and we were either in the hospital or in a rehab facility. I don't recall which at that time, but one or the other. And Mr. Bartholomew's comment is completely accurate.
Well, I understood that there was an illness, and that was the genesis of Mr. Bartholomew's communication with the court.
Yes, exactly, Your Honor.
But the fact of the matter remains, it's an improper communication, and it's the genesis of all of our problems in this regard.
Did you ever see the movie, Your Honor, The Cool Hand Luke?
Yeah.
You know the famous line?
What we have here is a failure to communicate.
Exactly.
But it's not a failure to communicate. It's a failure to follow the rules. Those are different entirely.
Yes, Your Honor. Just to finish then, the ruling is a motion for reconsideration is granted, and the hearing is rescheduled for August 7th at 11 o'clock, and defendant's counsel is to submit an order to that effect.
Yes. And the order will also provide that either party, if they wish, not required, but may supplement their previous pleadings on the motion to set aside default judgment.
Yes, Your Honor. I'm sorry I missed that. You're correct. Of course.
Is there anything else, gentlemen?
No, Your Honor.
It's really been lovely, but I have a docket to get to.
Thank you, Your Honor. I appreciate the time. Have a great rest of the day.
Thanks. Be careful, gentlemen. Take care of yourselves.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, we'll go ahead and get started. I'm calling file number 23-
If you thought that was bad, wait till you hear from this guy.
17356-UN. It's the matter of Shakina McCauley versus Rashawn Akins. And this is the date and time set for a hearing on the defendant's objection to notice of registration of a Missouri child support order here in the state of Michigan. Appearing at today's hearing via Zoom.
You got to wait for his argument. It's fantastic.
The defendant, Mr. Akins. And Mr. Akins, I will go ahead and swear you in. This is your objection. If you would please raise your right hand.
Yes, sir.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. And what would you like to say today in support of your objection to the registration of the Missouri child support order here in Michigan?
Your Honor, there's really nothing to say. I'm just ready to get this over with because I ain't finna go through he say, she say, but I'm just trying to get this taken care of because, Your Honor, I'm not I'm not fit to take care of my children on what they're going.
I ain't finna go through he say, she say. Okay, Judge?
I'm not. Including you can't take care of your children if you can't take care of yourself. That's all I'm like. I can't take care of myself. If I can't take care of myself, I cannot take care of my children. Like, I got to make sure I'm fit. Then I can make sure my children is good. You know what I'm saying? Like, if you have children, sir, you know what I'm saying. Like, we got to make sure we straight. Then our children is straight, Your Honor. What they got me doing right now, Your Honor, even I got multiple cases out of
the judge's complete lack of expression's fantastic. It's so good. He can't even believe he's hearing this crap.
Missouri with child support. I don't mind taking care of my kids. That's not the problem. It's just I don't make what I make no more, Your Honor.
Okay.
You know? So I ain't no excuses for nothing.
I understand. So what you'll need to do is file or basically make a request in the Missouri court where your case is. Do you know what court that is?
I don't know, Your Honor. I came up here to start over and
so
live a bit.
Okay.
Go ahead.
It's in Dunklin County, Missouri.
Yes, sir. That's where I'm from.
So what you'll need to do is contact the Dunklin County Court and ask them to look at your child support and modify it, lower it, okay?
And that's what I'm saying, Your Honor. She want $1,067 a month, Your Honor. I make $1,000 a month.
Right.
Like I'm literally, I cannot survive here. Our cost of living here is way different from where I'm from.
So under the statute that I have to go by, inability to pay the support order is not grounds to stop it from being registered here in Michigan. That's a good argument if you want to change the amount, but to do that, you'd have to ask the court in Dunklin County, Missouri to change the amount. Because this court doesn't have the authority to change the amount.
And that's what I'm saying, Your Honor. She transferred up here. Why don't they have the authority?
Well, because under Michigan law and also Missouri law, the Dunklin County Court has the continuing authority to do that, and only Dunklin County has that authority.
And that's what I'm saying, Your Honor. Like, they garnish it so much. Like, even today, my check, I got paid today. My check was $78, Your Honor. I don't know how I can survive off of it.
So
I don't. Like, my last check last week was 98. The one before that was 106. I cannot survive.
So do you have any questions about the court that you should, give a call to ask to have this looked at to lower it?
Even when I called them, they say get a lawyer. I can't afford one. I can't.
And I don't have the ability to appoint you a lawyer for that Missouri case. I'm very sorry. Okay. So at this point, I have to, deny the objection because it looks like, your argument that you have the inability to pay this amount, that's not an argument that would prevent the order from being registered here in Michigan.
Well, there you have it. There you have it. We end on a low note. Oh, that was from Kristen in Traverse City. The argument was so spectacularly bad, I had to roll with it. Even after the Gong Show incident, as it came to be known. Oh, but remember all the way back when we were watching Peckerwood and things were good. And it just descended. All right. Thank y'all for coming out. I put a redirect to Biggin if you guys are interested. I will see y'all soon.